Welcome to the Supreme Court Podcast.
All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
In 2003, the Office of the Ombudsman received an anonymous complaint on the alleged misuse of public funds through fictitious grants to dummy cooperatives, implicating several officials in the Vice Governor's Office of Sarangani Province. 2 years after, the Ombudsman filed an information charging petitioner Cesar Matas Cagang, then Provincial Treasurer of Sarangani, and several others with malversation of public funds through falsification of public documents for alleged misuse of 375,000 pesos for bogus financial assistance to a fisherman's group. The Sandiganbayan acquitted him and others for insufficiency of evidence. In 2011, Cagang and other provincial officials were charged with malversation through falsification and violation of Section 3E of RA 3019 in relation to a 350,000 peso disbursement to a cooperative that allegedly never requested or received financial assistance. The funds were released based on fabricated documents, and Cagang was identified as having certified the availability of cash for this purpose. Cagang filed a motion to quash and argued that there was an inordinate delay in the filing of informations in violation of his constitutional rights to due process and speedy disposition of cases. When the Sandiganbayan denied his motion for reconsideration, Cagang brought his case to the Supreme Court. Under what conditions can inordinate delay cause a case to be dismissed, and how do courts evaluate such delays? What is inordinate delay, and how does it affect a case in a legal proceeding? How do courts ensure both due process for the accused and the state's right to fair prosecution? Hi, I'm Attorney Mike Navallo, Supreme Court Chief Communications Officer. It's the 5th of September 2025, and today we talk about inordinate delay and how it affects a case in a legal proceeding within the context of the consolidated cases of Cesar Matas Cagang versus Sandiganbayan et al., GR numbers 206438 and 206458, and Cesar Matas Cagang versus Sandiganbayan et al., GR numbers 210141-42, penned by Senior Associate Justice Marvic M.V.F. Leonen, decided on July 31, 2018. And joining us to discuss this case is Sandiganbayan Justice Michael Frederick L. Musngi, who served as bar examiner in Remedial Law during the 2022 bar examinations. Hi, Justice Mike. Welcome back to the Supreme Court Podcast.
Hello, Attorney Mike, and thank you for having me again.
All right. Good to have you back. Now, to start our discussion, Justice, could you briefly explain to us what the idea or the concept of inordinate delay means, and what would constitute inordinate delay in a legal proceeding?
Inordinate delay was first defined in the case of Tatad versus Sandiganbayan as an unjustifiable excessive delay in the investigation or prosecution of a case that violates the constitutional right to speedy disposition of cases. It considers both the length of delay, the reasons for the delay, its timely assertion, as well as the prejudice caused to the accused. So, inordinate delay is a ground for violation of the right to speedy disposition of cases under Article 3, Section 16, and not typically applied to the right to speedy trial under Section 14, Paragraph 2 of the Constitution.
Before we go to the distinction, Justice, how do courts determine whether a delay is unreasonable or justified?
As Judge Leonen stated in Cagang, delay is not determined through mere mathematical reckoning, but through the examination of the facts and circumstances surrounding each case. Courts should appraise a reasonable period from the point of view of how much time a competent and independent public officer would need in relation to the complexity of any given case. The court has also used the Barker versus Wingo balancing test, which provides that courts must consider the following factors when determining the existence of inordinate delay. First, the length of delay. Second, the reason for delay. Third, the defendant's assertion or non-assertion of his or her right. And fourth, the prejudice to the defendant as a result of the delay.
Mhm. And when you talk about inordinate delay, Justice, how do you distinguish this from procedural delay and also another concept, institutional delay?
Inordinate delay, Attorney Mike, is an unreasonable, unjustifiable, and excessive lapse of time in the conduct of preliminary investigation or trial that violates the constitutional right to speedy disposition of cases. Procedural delay arises from non-compliance with procedural timeframes set by law, the rules of court, or internal regulations. For example, the rules of criminal procedure, the ombudsman rules, the guidelines for continuous trial in criminal cases, etc. In Kagang, it was discussed that institutional delay is a reality that the court must address. The prosecution is staffed with overworked and underpaid government lawyers with mounting caseloads. The court's dockets are congested. So this court has already launched programs to remedy this situation, such as the judicial affidavit rule, guidelines for decongesting holding jails by enforcing the right of the accused to bail and to speedy trial, and the revised guidelines for continuous trial. These programs, however, are mere stepping stones according to Judge Leonen. The complete eradication of institutional delay requires these sustained actions. Institutional delay, in the proper context, should not be taken against the state. Most cases handled by the Office of the Ombudsman involve individuals who have the resources or who engage private counsel with means and resources to fully dedicate themselves to their client's case. More often than not, the accused not only invoke the right to speedy disposition of cases when the Ombudsman has already rendered an unfavorable decision. The prosecution should not be prejudiced by private counsel's failure to protect the interests of their client or the accused's lack of interest in the prosecution of their case.
Mhm. And when should the clock start ticking for determining inordinate delay, Justice?
The period for determination of whether inordinate delay was committed shall commence from the filing of the formal complaint and the conduct of the preliminary investigation. The period taken for fact-finding investigations prior to the filing of the formal complaint shall not be included in the determination of whether there has been inordinate delay.
And for the benefit of our listeners, this is peculiar to the Office of Ombudsman that there is a fact-finding investigation first before there's a formal complaint filed with the Ombudsman, Justice, right?
Yes, in previous rulings by the Supreme Court, they considered the period exerted or spent for fact-finding investigations in addition to the period actually conducted by the Ombudsman for preliminary investigations in determining the length of time that is a consideration when you think about inordinate delay.
And let me digress just a bit, Justice. When we talk about inordinate delay, do we have a mathematical period in mind for this, or there are several factors that you need to look into before you can say there's inordinate delay? It's not just number of years.
Not the number of years or the length of time is really just the most important aspect. As Judge Leonen mentioned and emphasized here, mathematical reckoning is not the primordial or the important consideration here, but certain factors are most importantly considered, like the length, the reasons for the delay, the prejudice to the accused is the most important thing, because when the delay is inordinate, it deprives the defendant or the accused with much needed resources, or the witnesses may no longer be available when it's his turn to offer his defense.
And of course, the consequence, Justice, if you raise inordinate delay, does that necessarily lead to the dismissal of the case?
It dismisses the case with prejudice, so you can file the case anymore as against that particular defendant or accused. It becomes barred by double jeopardy. So that results in an acquittal.
So in this case, in the case of Cagang, there was a motion to quash filed. Why did the petitioner file the motion to quash? And if you could also briefly explain what a motion to quash is, Justice.
A motion to quash is a request made by the accused in a criminal case asking the court to dismiss or quash the complaint or information before entering a plea because of specific legal defects. The grounds are provided for under Rule 117 of the Rules of Court, such as failure to state a cause of action, lack of jurisdiction, prescription, double jeopardy, etc. If granted, the case is dismissed, though sometimes it can be refiled if the defect is curable. If denied, the case proceeds to arraignment and trial. Cagang filed a motion to quash the information filed against him because he alleged that it violated his constitutional rights to due process and to speedy disposition of cases. Cagang said that the alleged anomalous transactions in this case were already thoroughly investigated by the COA in its audit report. Thus, the Office of the Ombudsman should not have taken more than 7 years to study the evidence needed to establish probable cause. He contended that, quote-unquote, when the Constitution enjoins the Office of the Ombudsman to act promptly on any complaint against any public officer or employee, it has the concomitant duty to speedily resolve the same.
And Justice, in this case, how did the Supreme Court rule on Cagang's petition?
The petition was denied. The Supreme Court noted that although the case had been pending since 2003, the petitioner invoked his right to speedy disposition of cases only upon the filing of the informations on November 2011. While there was indeed delay, the petitioner failed to demonstrate that he had asserted his right at any time during the intervening period, electing instead to remain silent until charges were filed before the Sandiganbayan. Moreover, the case involves the alleged malversation of millions of pesos in public funds. The records further revealed that the transactions under investigations were both complex and numerous. More than 100 individuals were investigated, with 40 ultimately found to be involved in 81 separate anomalous transactions.
So there was no violation of his right to speedy disposition of cases, Justice.
Yes, there was no violations because the Supreme Court mentioned that the accused here failed to assert his right in a timely fashion.
And just for the benefit of our listeners, how do you distinguish the right to a speedy disposition of cases from the right to a speedy trial?
While the rationale for both rights is the same, the right to a speedy trial may only be invoked in criminal prosecutions against courts of law. The right to speedy disposition of cases, however, may be invoked before any tribunal, whether judicial, quasi-judicial, or even administrative.
So when does the burden, Justice, assuming you are in a case where there are some delays, when does the burden shift from the defense to the prosecution in cases there are delays?
Generally, it is the accused who has the burden of proving that the delay is inordinate. However, the burden shifts to the prosecution to prove that the delay is reasonable if the prosecution exceeds the prescribed period stated in Ombudsman Administrative Order Number 1. If the right to speedy disposition of cases is invoked within the given time periods contained in the rules, the defense or the accused has the burden of proving that the right was justifiably invoked. If the delay occurs beyond the given time period and the right is invoked, the prosecution now has the burden of justifying the delay.
So what's striking for me here, Justice, is that the silence or inaction of the accused can be treated as a waiver of the rights?
The Supreme Court here said yes. Even if the Ombudsman had in fact incurred delay in the conduct of preliminary investigation against Cagang, the latter is precluded from invoking his right to speedy disposition as he failed to assert the same in a timely manner.
And let me just backtrack a bit, Justice. You did mention the Tatad doctrine earlier in our discussion. What is the Tatad doctrine and is it still relevant today?
The Tatad doctrine holds that when inordinate delay is established, the court may grant the quote-unquote radical relief of dismissing the criminal complaint against the accused on the ground that the prolonged termination of the preliminary investigation violated the constitutional right to speedy disposition of cases. So, yes, Tatad is still relevant today, but it was refined by the ruling in Cagang. After Cagang, courts must first determine which party carries the burden of proof. If the right is invoked within the given time periods contained in the rules, the defense has the right of proving that the right was justifiably invoked. If the delay occurs beyond the given time period and the right is invoked, the prosecution now has the burden of justifying the delay. If the defense has the burden of proof, it must prove first whether the case is motivated by malice or clearly only politically motivated and is attended by utter lack of evidence. And second, the defense did not contribute to the delay. Once the burden of proof shifts to the prosecution must prove first that it followed the prescribed procedure in the conduct of preliminary investigation and in the prosecution of the case. Second, that the complexity of the issues and the volume of evidence made the delay inevitable. And lastly, that no prejudice was suffered by the accused as a result of the delay.
And usually, Justice, in cases like this, when you involve graft and you have corruption against public officials, some of the cases could be complex. Can you cite the complexity of the case as a reasonable justification for the prolonged proceedings?
Yes, the courts must consider the entire context of the case, from the amount of evidence to be weighed to the simplicity or complexity of the issues raised. An exception to this rule is if there is an allegation that the prosecution of the case was solely motivated by malice, such as when the case is politically motivated or when there is continued prosecution despite utter lack of evidence. If malicious prosecution is properly alleged and substantially proven, the case would automatically be dismissed without need of further analysis of delay. Another exception would be the waiver of the accused of the right of speedy disposition of cases or the right to speedy trial. If it can be proven that the accused acquiesced to the delay, the constitutional right can no longer be invoked.
How should the courts balance due process for the accused with the state's right to prosecute?
The right to prosecute must be balanced against the state's duty to respect the fundamental constitutional rights extended to each of its citizens. Thus, the courts must protect the accused from oppressive delay while avoiding impunity by giving the state reasonable time to prosecute. The goal here is fairness, ensuring that justice is neither rushed nor denied.
And I know you mentioned this earlier, Justice. Should fact-finding investigations count toward delay computations?
In this case, said no more. The Supreme Court expressly abandoned the ruling in People v. Sandiganbayan 5th Division, which had included the period of fact-finding investigations in computing the period for determining inordinate delay.
All right, and just to close our discussion, Justice, what should be our key takeaway from this discussion?
First, really, is the right to speedy disposition against the right to speedy trial. These are distinguishable legal concepts. The right to the speedy disposition may pertain to administrative or quasi-judicial functions, but the right to speedy trial only applies to criminal prosecutions in the judicial sense while the case is pending in court. Second, the case initiation and delay computation. In filing a formal complaint prior to the conduct of a preliminary investigation. In this case, the court acknowledges that the Ombudsman should set reasonable periods for preliminary investigation with due regard to its complexities. Delays beyond this period will be taken against the prosecution. And third, burden of proof. Courts must first determine which party carries the burden of proof. If the right is invoked within the given time periods contained in its rules, the defense has the burden of proving that the right was justifiably invoked. If the delay occurs beyond the given time period and the right is invoked, the prosecution has the burden of justifying the delay. If the defense has the burden of proof, it must prove, first, whether the case is motivated by malice or clearly only politically motivated and is attended by utter lack of evidence. And second, that the defense did not contribute to the delay. So once the burden of proof shifts to the prosecution must prove first that it followed the prescribed procedure in the conduct of preliminary investigation and in the prosecution of the case. And second, that the complexity of the issues and the volume of evidence made the delay inevitable. Lastly, that no prejudice was suffered by the accused as a result of the delay. Fourth, the contextual evaluation of delay. The court said that determination of the length of delay is never mathematical nor mechanical. The courts must consider the entire context of the case, from the amount of evidence to be weighed to the simplicity or complexity of the issues raised. An exception to this rule is if there is an allegation that the prosecution of the case was solely motivated by malice, politically motivated, or when there is continued prosecution despite utter lack of evidence. Malicious intent may be gauged from the behavior of the prosecution throughout the proceedings. If malicious prosecution is properly alleged and substantially proven, the case would automatically be dismissed without need of further analysis of the delay. Another exception would be the waiver of the accused to the right to speedy disposition of cases or the right to speedy trial. If it can be proven that the accused acquiesced to the delay, the constitutional right can no longer be invoked. And lastly, most importantly in this decision, the timely assertion is required. This right to speedy disposition of cases or the right to speedy trial must be timely raised. The respondent or the accused must file the appropriate motion upon the lapse of the statutory procedural periods. Otherwise, they are deemed to have waived their right to speedy disposition of cases.
So you should always be vigilant to safeguard your rights and
That's
not
right.
sleep on it. Thank you very much, Justice. Very comprehensive summary of our discussion today. And thank you again for accommodating us.
Maraming salamat, Atty. Mike, and good luck.
All right. Thank you, Justice. And if you wish to read the full text of the court's decision, please visit the Supreme Court website and e-library. Look for Cesar Matas Cagang versus Sandiganbayan et al., GR numbers 206438 and 206458. Here's Tiff Atendido Beltran, Supreme Court Information Officer, for this week's Roundup.
From the Supreme Court of the Philippines, here's the latest. In a historic first, 5 sitting justices of the Supreme Court visited the island province of Cebu to formally mark the start of the construction of its Hall of Justice. Chief Justice Alexander S. Mundo led the SC delegation. He was joined by Senior Associate Justice Marvic M.V.F. Leonen and SC Associate Justices Josep Lopez, Japar de Maampao, and Jose Midas Marquez. They were welcomed by Governor Abdusa Curtan II, Vice Governor Abdusa Curtan, Sulu 1st District Representative Samyar Tan, and Kusug Tausug Party List Representative Ayman Tan, who all hailed the justices for making the first ever trip of any sitting justice to Sulu. Presidential Advisor on Peace, Reconciliation, and Unity, Secretary Carlito Galvez Jr., accompanied the justices who flew from Zamboanga to Sulu via 2 Black Hawk helicopters. In his message, Chief Justice Hesmundo emphasized that the HOJ's construction is a statement of purpose to build not only a physical structure but a more just, more stable, and more hopeful future for the people of Sulu. The new HOJ will feature a glass structure with a neoclassical facade and will be located at the Sulu Provincial Capitol Grounds in Patikul, Sulu. The Judicial and Bar Council, or JBC, on Monday, September 1 and Tuesday, September 2, concluded the public interviews of applicants for the position of Ombudsman at the Supreme Court On-Bank Session Hall. On Monday, the candidates interviewed were former SC Associate Justice Mario Lopez, Sandiganbayan Associate Justice Michael Frederick Musngi, Office of the President Deputy Executive Secretary for Legal Affairs Ana Liza G. Logan, and solo practitioner Attorney Melvin Matibag. The last batch interviewed on Tuesday consisted of Justice Secretary Jesus Crispin Remulla, Philippine Charity Sweepstakes Office Chairperson Felix Reyes, Municipal Trial Court Judge Jason Rodenas, and Acting President and Chief Executive Officer of Natural Resources Development Corporation, Benjamin Turgano. The applicants seek to replace retired Ombudsman Samuel Martires, whose term expired on July 27, 2025. On Monday, Sandiganbayan Associate Justice Maria Teresa Dolores Gomez Estuesta took her oath as the new court administrator before Chief Justice Alexander Esmundo. She replaces the Honorable Raul Villanueva, who is now an SC Associate Justice. Prior to her appointment, she served as chairperson of the Anti-Graft Court's 7th Division. Meanwhile, on Tuesday, His Excellency Mark Enos Brown, newly appointed Ambassador of the Commonwealth of Australia to the Philippines, paid a courtesy call on Chief Justice Alexander Esmundo and the SC Associate Justices at the SC Bank Session Hall. Present were Associate Justices Alfredo Benjamin Cagiwa, Amy Lazaro Javier, Rodil Zalameda, and Jose Matas Marquez. Chief Justice Esmundo discussed the projects under the Strategic Plan for Judicial Innovations 2022 to 2027, or SPJI, supported by the Australian government through various development partners such as the Fair Justice Program and the SC's current partnerships with the Australian judiciary. For his part, Ambassador Enos Brown lauded the court's reform programs to improve access to justice and affirmed Australia's partnership with the Philippines. Meanwhile, the Office of the 2025 Bar Examinations Chairperson, SC Associate Justice Amy Lazaro Javier, advises the public on road closures ahead of the 2025 bar examinations to be held on September 7, 10, and 14, 2025. Some roads in the vicinity of the 14 local testing centers of the 2025 bar will be subject to intermittent closure and the implementation of traffic management guidelines on the said dates. Motorists and commuters are advised to take alternative routes where possible and to follow the instructions of traffic enforcers stationed in the areas. The office also issued guidelines for number coding exemption. Bar examinees are exempted from contactless apprehension but are required to register one vehicle for number coding exemption until September 8, 2025. On September 1, 2025, the Free Legal Assistance Group, or FLAG, presented Chief Justice Esmundo a copy of the book Frontliners for Human Rights, Flag of the People at 50 at the SC compound in Manila. Attorney Theodore Te, FLAG interim chairperson, led the presentation. Also present were Senior Associate Justice Marvic Leonen and Associate Justices Amy Lazaro Javier and Jose Matas Marquez. The book commemorates FLAG's 50 years of defending human rights in the Philippines. It will be launched this month in different universities around the country. Finally, the SC and the Philippine Women Judges Association, Inc. announced the opening for the nominations for the 2026 Search for the Her Story Gender Award of Distinction awardees. The award celebrates inspirational stories of female judges who have triumphed over professional and personal challenges. Submission period is until November 30, 2025. You are now up to date with the Philippine Supreme Court. I am Tifat Beltran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navallo, your Supreme Court Chief Communications Officer. You can catch this podcast and the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Karen Martinez, Jay Rempilio, and May Sibal as researchers, Brian Ostrea, Don Ryan Balza, Victor Laranio, Lawrence Olanio, Austin Aliscad, and Bea Batung as audio and video editors, and Taik Flores and Jerome Batumalake as web editors.